The case is now being recorded. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Thank you very much. Good afternoon, everybody. This sitting of the Appeals Court is, of course, being conducted by video conference rather than in person. I am Justice Rubin, and I'm joined today by my two colleagues, Justice Henry and Justice Grant. We will be hearing a single case. It is number 21-846, Gaskins versus BAEZ. And we will hear first from you, Mr. Gaskins. Whenever you would like, you may proceed.
Okay, thank you, Your Honor and Honorable Justices, for this court session. This case centers around mail, First Amendment protections, Article 16 protections. And one of the things is about contraband and seizure mail and contraband without giving proper notice, pursuant to the 103 CMR 481 regulations. So when we was in the lower court with these issues, summary judgment was granted to the defendants, I think prematurely, because we raised enough, well, I raised enough to show that there was a legitimate dispute, and it should have been, the matter should have been able to allow to go forward. So the court raised the question around issue number 4, based on, no, excuse me, not issue number 3, based on the 5 pages that was provided to me outside of the contents of trial transcripts that was sent to me through the mail, and 5 pages of a decision that was sent to me through the mail as well. So I would answer that first and then try to deal with the rest of them later. So what happened in this particular case, a gentleman named Jose De La Cruz, whose case I've been working on for a lot of years, and who I'm permitted to do so under Johnson versus Avery, sent me some trial transcripts at the facility. And all but 5 pages of the trial transcripts were seized. I don't know what happened to the rest of the pages, but I received five pages of it, and I grieved it. So what I was told, based on the response and the grievance, is that it has to be mailed to me through some type of authoritative figure, i.e. either the courts or a lawyer, which is just not true, because it's just mail coming in. So it's not necessarily deemed privileged mail, but it had a legal context behind it when it came into me. So under the rules that the DOC policy states that any type of internet copies coming into the facility in excess of 5 pages would be deemed contraband. So only 5 pages are allowed per envelope. So the response in the grievance said that since the contents of the mail were photocopies attached to personal correspondence forwarded by a person not specified in section 10 of 103 CMR 481 under the 2017 version, that they're deeming it the materials of publications where I'm only allowed to receive a maximum of 5 pages.
Mr. Gaskins, I have a question for you. My understanding is that DOC is saying they determine whether something is legal mail by who the sender is and not the contents of the mail. Are you saying that's wrong and they should look at the contents of the document?
I'm not saying that they're wrong. What I'm saying is that this is just mail that's coming in. It just had a legal context behind it, and it wasn't necessarily coming in as legal mail. It was coming in as regular mail, but it had a legal nature behind it because it was trial transcripts that I needed to get in my possession so I could read them.
And in that particular situation, you're serving as someone who's providing some legal counsel?
Yes, I'm assisting this person under the rules of Johnson versus Avery. So I'm allowed to help other prisoners and stuff. And this man is in New Jersey. He was transferred out of New Jersey State Prison. So we correspond back and forth in the mail. So I asked him to send me stuff so I could look at it and see if I could provide assistance to him. So that's what I've been doing. I've been assisting him since he's been out there.
Were you ever incarcerated in the same institution?
We were briefly. I never met him physically. We were briefly in Sousa Baranowski when he got transferred out of state. And
did you begin providing legal assistance to him while you were both in the in Sousa Baranowski?
Yes, because what happened was I met him through correspondence through somebody else saying that he needed some help and he was in a different part of the facility. So I was helping him while he was in a different part of the facility, and then he was transferred out of state.
Is
So-
his conviction a Massachusetts conviction, but he's simply being housed out of state?
Yes, sir. And he has no Massachusetts law out there. He don't know how to do anything.
And it's a Massachusetts state conviction? Or
Yes, sir.
federal state
It's
conviction?
a Massachusetts state conviction, sir.
Interesting. Okay.
And so now before this happened, I received transcripts from him prior to that. I just couldn't get to it. And I received all of them when I was at MCI Norfolk back in 2012 or 2013. I had the same transcript sent to me and I received them in full. Then when he sent them to me back in 2017, I only received 5 pages and the Department of Correction used the publication section of their policy to deprive me of the rest of the pages of the transcripts.
So is it your position that this transcript and the appellate brief that Mr. De La Cruz sent you, that they're publications or not publications?
They're not publications for the simple fact that publications is defined within the regulations very clearly. And if they was gonna use regular mail as to fall up under the context of publication, then when they changed the regulations back in 27, which is the newest ones, they would have put it in there. So under publications, in the CMR 103, CMR 40, 106, it clearly states what a publication entails. It states that any book, booklet, pamphlet, magazine, periodical, newsletter, newspaper, or similar document, including stationery and greeting cards, published by any individual, organization, company, or corporation which is distributed or made available through any means or media for commercial purpose. And it goes on to say this definition includes any portion extracted, photocopied, or clipped from such items. Nothing in here says that personal mail would be deemed a publication. This thing was created for internet purposes only. Anything that was photocopied off the internet, that's what this policy was created.
But you agree that if he had sent you a magazine attached to a letter in personal mail, that would be a publication?
Yes, it would. And if he sent it beyond 5 pages, then you got to restrict it to 5 pages.
Okay.
So I don't disagree with that, Your Honor.
So why isn't a trial transcript a document that's published by an individual, the court reporter, or the court, distributed or made available through any means for a commercial purpose?
Well, I don't think it would fall up under commercial purpose, because I would believe that when you're looking at it from the internet, because Gus versus Dennehy is the one that set the parameters on how this publication section of this CMIs was going to be looked upon. And in that, they clearly identified what is and what's not a publication. And one thing is not a publication is if I receive, not from the internet, but from a court system, that papers and documents in excess of 5 pages.
What is the Dennehy, what is that case that you're describing?
Gus versus Dennehy, let me get the site. It's GUZZ versus Dennehy. It's a 2009 decision, and it was reported under 25 Mass Lawyers Reporter 207. And under that case, it was held that DOC changed its policy so as to permit prisoners to receive up to 5 pages per day of extractions from internet publications through the mail.
And this is a decision of the Superior Court?
It's either a decision, I don't know what Mass Law Reporters fall up under, but whatever Mass Law Reporters fall up under, that's what it's called.
And is this in your brief, that case?
Yes, it is. So on page 14.
Oh yeah, I see it on page 14. Okay, we can look that up. We obviously can look that up.
Well, so do the words for a commercial purpose, doesn't that just mean someone gets paid to produce it?
Well, I'm looking at it from the aspect, if you look at it commercial purposes, you would look at it from the aspect of not necessarily somebody benefiting from it. It's something that have a content behind it that doesn't have a commercial aspect behind it. So let's say trial transcripts don't necessarily have a commercial aspect behind it, because when you look at something commercial and you look at it under commerce, there's some type of gain or benefit behind it. This is just documents that's being published and sent to a person. So if I'm receiving my trial transcripts, so I could give an example right now. I have my personal trial transcripts, and if my lawyer don't send it to me and say I have a copy at home, and I tell my family, please send me my trial transcripts because I need them to look at so I could be able to try to, attack issues on my case. When they send them in, they would just say, no, you can't get them all. We're only going to give you 5 pages of it. And so that would be depriving me of access to my own access to the courts, because I would be deprived these legal documents to be able to possibly pursue, some type of legal ramifications or just, excuse me, you gotta bear with me, please.
No, you're doing well.
So the thing is that interference in this nature has some kind of significance to it, because it's depriving a person of being able to pursue some type of legal avenue for some type of judicial redress or recourse. So I don't believe that you could lump it up under as a commercial item, and that it will fall up under the context of a publication that's defined as in the regulations, which has the force of law. So under this, which has the force of law, it clearly states what the DOC can deem a publication, and it doesn't say nothing about trial transcripts or any type of court documents coming in, whether if it's from an authorized figure such as a clerk or attorney or district attorney. It could come in through the legal mail. It could come in through a regular mail as a protected speech under the First Amendment. So it never was a problem until 2017. So that's why I had to outline that. And I don't know why all of a sudden it became a problem.
You're saying that prior to 2017, even though this regulation was in place, it wasn't being used to limit to 5 pages attachments that were government documents like that?
No, sir. I got the proof. I got the proof because I had a similar situation that happened here in 2012 at MCI Norfolk. 5 volumes of trial transcripts were sent in the mail. I was told that it was deemed contraband because it exceeded the 5 pages. I filed a grievance statement specifically what publications entails. And then the director of security at the time, Sean Medeiros, walked up to my cell inside segregation and handed me all 5 volumes of the transcripts and said that was a mistake on our part and gave it to me.
Interesting.
And that's the truth. Then, so hopefully that kind of give you an answer to that question that the court raised. So the other matter that seems of importance is the glitter mail issue. And what had happened was my daughter always sent me a card. She sends it to me and she writes in glitter pen all the time. So around 2017, 2016, they started saying, okay, well, this is deemed contraband. So I explained to them, I said, well, first of all, if it's contraband or if you suspect of anything, then you probably need to test it to see if there's anything wrong with it. Because prior to this, there's never been a problem with this because I have lawyer friends who send me glitter cards. And so once they did that, I could no longer receive cards from my daughter, who she always writes in glitter pen to me, nor could I receive the cards that my lawyer friends used to send to me in the mail.
But
So,
can I ask you a question about this?
yes, sir.
If the department concludes that there's a whole category of something that could easily be used to hide contraband, that is something that you can put on a kind of paper that you can hide drugs in, a kind of something that might be used to mask drugs, something like that. Are you saying they have to test every single item that comes in? They can't make a rule that says, look, this is a particularly risky kind of whatever, paper, ink, paint, whatever it is.
Yeah.
And so we're just going to not let this in. So we don't have to go through every page and try to see, is there maybe some, something put into the paper. We're just going to make a rule and people can still write to you. And it's unfortunate it can't be in glitter pen, but they can still write to you. Are you saying they can't do that?
I say it has to have a due process element behind it. And here's the reason why. We're dealing with First Amendment protections, all right? Freedom of speech and right to receive thoughts and ideas and information from the outside. So this don't just involve the First Amendment protection from my aspect. It also involves the First Amendment protection from the sender.
Of course.
So the sender expects for me to receive the contents. So if the DOC was such up in arms about this, number one, Your Honor, is that they never produced one piece of evidence that this ever occurred prior to implementing this policy. I would say it's a policy. And number two is, based on their new regulations that they had implemented in 2017 and 2018, they didn't address the glitter mill at all. There's nothing in there. However, they do got a section in the CMRs, as I point out inside the pleadings, dealing with contraband and how they deal with it. And it's supposed to be on a case-by-case situation. And here's the reason why it should be that way, because everybody's not up to something nefarious, number one. Number two, it places a defective character on the person sending the mail as if they're doing something nefarious without no such proof. So even if you use the security, you just can't blankly just use security to try to deny people protections that the Constitution compels. Okay. So in a particular case like this, I would say it's based on the regulations, it's supposed to be on a case-by-case situation.
Okay. Your time has expired. Do you feel like you've told us everything you need to tell us?
Yes.
All right. You've done an excellent job. I know it's difficult for someone who's not a lawyer,
yes,
and you've done an excellent job. So thank you very much. We'll hear now from you, Attorney Handler.
Thank you, Jan.
Yes, Your Honors. To start with, I just want to indicate that Mr. Gaskins below had argued specifically what Justice Grant suggested, which was the documents should have been classified as legal in nature because they were legal related, and therefore the issue of publication was not briefed entirely before this court because that was not a question on the appeal. Regardless, I am prepared to address it. I did want to bring to Your Honors the appellate Rule 23 decision of Hudson versus Turco, and that number is 19P906. I believe that decision is almost precisely on point, indicating that the department
So counsel, we're familiar with Hudson, but does it specifically grapple with this issue about whether a trial transcript is qualifies as a publication under the definition in the regulation?
Right. Well, what it does say is that the plain language of the inmate regulations relating to publications can readily be interpreted as the defendants do to include copies of legal research materials. So I believe that that does contemplate.
Yeah, that's the problem we're having, though. Could you just, since it's so readily apparent, could you just explain it to us?
I absolutely can. And before I do want to correct factually what we're talking about here, because if Your Honors look at the record, specifically at page 58 of the supplemental appendix, there are two mailings from Ms. Babcock, and on page 58 there is an order from the U.S. District Court, and on page 60 there is a grievance regarding the trial transcript. There was no transcript from Jose de la Cruz. So just factually, the transcript was sent from Barbara Babcock.
I thought there was a brief sent by Mr. de la Cruz.
Yes, there was a brief sent by Mr. de la Cruz, but Mr. Gaskins had said there was a brief and a transcript. I actually have a copy of the mailing from Mr. de la Cruz. I would be happy to provide it via 16L to the court. But what I wanted to point out is that the brief was filed in the New Jersey Superior, actually in the federal court, I believe, electronically by another attorney. It was filed by the Duke University School of Law Appellate Law Clinic. It was not filed by Mr. de la Cruz. It is a document that is of record in a federal court. Mr. Gaskins could obtain that through the law library at whatever institution that he is housed at. He could request it.
I don't know if all briefs or transcripts are available in a prison law library.
Right, with this second part is the prison law libraries do have PACER. In the alternative, he could write directly to the court and obtain it from the court, which would make it privileged mail, and he could receive it in its entirety.
Okay, but can you address the question of whether it's produced for a commercial purpose? Because I would have thought that a government document is not produced for a commercial purpose.
I will, when with regard to the definition of publication, if I could, just one moment, Your Honor, I'm going to pull out the my brief, which has the wording of first of all, Your Honors are, I believe, satisfied that it is not a privileged document, and I should go on to the question of publication.
We don't have even the 5 pages of the trial transcript or the appellate brief that Mr. Gaskins received. Those aren't in the record, right?
It was not in the record because Mr. Gaskins' argument below was solely based that it was legal based upon this, the content as opposed to who sent it. And the department's position was the sender is what makes the sender with it brings various indicia of reliability, that it will not include contraband, encrypted messages. Often there is in the record from the affidavit of Stephen Silva that you have to look through any publication page by page, because the problem is that it can be altered from what it appears to be.
How would the prison mailroom person ordinarily decide whether or not something was for a commercial purpose? Does it have to have like a copyright notice or a price tag on it or something?
Well, the commercial purpose, if you're reading the regulation and the way the department reads the regulation, it is published by any individual, organization, company, or corporation. I would suggest the courts are an organization, and is distributed or made available by any means for commercial purpose. Now, I know there are charges for papers on PACER. This was a federal court. I would suggest that the department's interpretation is there does not need to be a financial component attached to it for a commercial purpose. In this case, there is. But the way that we interpret this is that the court is the keeper of those records, and if they are the distributor of those records. And
okay,
as
we don't charge, I don't think, I don't have any idea really, but when we send a prisoner an opinion in their case, we don't charge anyone anything. It's a government document that's being sent out. It's a legal document. It's not for a commercial purpose, right?
When you send it to the prisoner for his or her own case, if
Sure.
an individual wishes to obtain other documents, they often have to go through Westlaw, which is a commercial purpose, or in the federal courts, if you have PACER, it's 10 cents a page. This was a federal document.
This is a little bit tricky, I think, Attorney Handler, to begin calling legal documents for a commercial purpose.
The department's position, sorry, go ahead, Your Honor.
No, it just seems to me, I mean, I don't know. I haven't used PACER since taking the bench. I mean, I used to have a PACER account, you know, and maybe you have to pay per page or something, I don't know. But is there nothing then that's not for a commercial purpose?
I would suggest that the department's reading of this regulation is that a financial component is not required.
So I think what may have caught our attention was this. You defend the regulation, and throughout your brief, you talk about printed materials and publication, printed materials. I don't know when this regulation was adopted, and I don't know why, but it doesn't say that. It says for a commercial purpose. So we have to give those words some meaning, right? And I understand your defense of it, and it may be that a restriction on all attachments to no more than 5 pages wouldn't be a crazy regulation to have. But that doesn't seem like what this is, right? This seems to be something about commercial publications.
The department is entitled to deference in the interpretation of its own regulation. And we, the department, again, this was not briefed below, because Mr. Gaskins did not raise the issue. But the department's interpretation is that in fact, any attachment is limited to 5 pages. And the reason for that is set forth in the Hudson case, as well as in the Silva affidavit, that beyond 5 pages is a drain on facility resources to adequately.
But you can reasonably construe your regulation. This certainly doesn't say any attachment is limited to 5 pages. It obviously doesn't say that. So for example, I'm sitting here at home right now. If I chose to Xerox, I have a copy machine here. If I chose to copy 15 photographs and staple them together and attach them to mail, there'd be no commercial purpose of any kind involved, and it wouldn't fall within the regulation.
It would depend, Your Honor. The photographs, if they are of your own, there is a regulation with regard to photographs coming in. And if you were photocopying National Geographic photographs, I would suggest that they are publications.
But if they weren't, if they were just personal pictures I had taken of the bunny rabbits in my backyard, right, and I Xeroxed them and stapled them together, they obviously aren't covered by the regulation. To me, there's nothing commercial involved at any step of what I've described. So why do you say it's a reasonable construction of this regulation that any attachment can be limited to 5 pages?
Because the regulation itself includes any portion extracted, photocopied, or clipped from items provided. I believe that is a photocopy of items. I would suggest that does in fact fall within the regulation.
I don't know what's commercial about my photocopier on my desk here. Where's the commercial piece?
The commercial piece, I would suggest that is not the question specifically before the court. I would be happy to.
But we have to figure out what the regulation means.
Right.
And you said it means any attachment. And all I'm pointing out is it doesn't say that.
I would say any written attachment. It means any written attachment.
It doesn't say that. It says published for a commercial purpose. Are we disagreeing about that?
Well, the issue is the readability of the attachment to be reviewed.
No, the issue is whether it falls within the, I'm not saying, as I've said before, I absolutely understand the argument for a regulation that restricts all attachments to 5 pages. I understand what you're saying about workload and having to look at each page. That seems very reasonable to me. But that's not what the words of this regulation say.
I would suggest 2 things, Your Honor. I would suggest that issue is not before the court, in that Mr. Gaskins has not challenged the validity of the regulation on the basis of it being unconstitutionally vague. I would suggest that the Starr case, which was cited in the department's brief in the Hudson matter, it's a United States District Court case. There was a specific, and that case is Darren Starr versus Timothy Colomb, and that's a First Circuit case, docket number 091446.
Wait, that's what site? I'm sorry, what is that case?
Hang on, that's Starr case that talks about the facility has a legitimate interest in staff avoiding time-consuming.
No, I don't think anyone would disagree with that.
Okay.
Can I ask you one other question about the legal nature of this? I'm hoping we don't get into this, but we might.
Yeah.
You have defined legal documents by who sends them.
Correct.
After first post-conviction review, prisoners are not entitled to attorneys. And therefore, they're not going to have an attorney maybe sending them legal documents. but their mom or friend or brother might come across some quite interesting case or article or something legal and think it might have some bearing on their case and might want to send it to them. How would they do so?
I would suggest that they could send them the citation, and the inmate would be readily able to obtain that from the law library. And if it was not in the law library, the librarian would get it for them.
What if Mr. Gaskin's daughter was taking a class in school and wrote a term paper, a typewritten term paper that she wanted Mr. Gaskins to review? Could she attach that to a letter and send it to him? And would it matter if it was on a legal topic or not?
It would not matter if it was on a legal topic or not, and no, she could not attach that and send that to him. The danger is with the lengthy type material. If his daughter wanted to send him a 15-page handwritten term paper and wanted to take the time to do that, she could.
Wait, it's printed matter?
It's
typed?
Yes.
Can she type a letter and send it to him, or only a handwritten letter?
She can type a letter and
she
send
type
it to
a
you, but if
15
it's
page-
more than five,
Can she
if it's
type
more
a-
than 5 pages, there's no way for the department to determine that it is not a publication.
Wait, but not an attachment to the letter. The body of the letter is 15 pages long. She
Yes.
has a lot to tell him, and so she types "Dear Dad" at the top, and then there's text. And 15 pages later, "Lots of love, your daughter." You treat that as a publication. It's not an attachment at all.
Well, the department, here is the issue, Your Honor. The department has no way of determining that that is all of her 15
So you say,
pages.
is there a different regulation that says letters must be 5 pages or less?
Um,
Or letters must be handwritten?
no, and letters do not have to be handwritten.
So where do you get the authority? I understand an attachment. Where do you get the authority to cut off the last 10 pages of a 15-page typed letter? You think that it's publications? It's not a publication. It's not been published at all. It's just typed.
I don't have that answer for the court, Your Honor. Again, this was not an issue that was briefed, and that was not before the court.
All right. This turns out to be more interesting than I thought.
What I am happy to address the trial transcript issue as well. And I believe Justice Henry had said, and the department's position is the court reporter does have a commercial financial burden and financial interest in that. And in fact, you are not supposed to copy it and send it to anybody. It's supposed to come directly from the court reporter because that is how they make a living. I don't think there's any question with regard to the trial transcript being a publication for a commercial purpose. If the trial transcript was filed in court as an exhibit, I would suggest it also could be obtained from the court. Suggest that through the Turner analysis, even if this court were to determine that this was an infringement on plaintiff's First Amendment rights, if the court were to go in that direction, under the Turner analysis, whether it was a letter or whether it was an attachment or whether it was a photograph, I believe that under Turner v. Safley, the length of the document the department has would prevail that it is not a violation of plaintiff's constitutional rights.
But it might not be within the scope of the regulation.
I believe the department interprets its regulation to be within the scope, and we are entitled to deference on that. If you determine there is, and I can't put my hands on it right now, there is a case which indicates that I thought it was the Starr case that the constitutional, if I could just have one moment, that it determined that the publication definition was not unconstitutionally vague. I'm happy to provide that court.
That's fine. I don't. That's fine.
I do have that authority that I can't put my.
Again, I don't think anyone's arguing that it's vague. Your time has expired. Although I asked Mr. Gaskin, so I'll ask you, is there anything else you want to add?
I just want to say.
No. I asked you
sorry.
already, Mr. Gatz. I'm asking Attorney Handler.
Okay, I'm sorry.
And I also gave you a chance to say something
Yes,
else.
yes, I
So,
did. You're right.
so your time's expired, but do you have anything else, Attorney Handler? Or?
Yeah, I would just point out that Mr. Gaskins did not raise this issue at the lower court. It has not been briefed. I would suggest he has waived it entirely. But if your honors determine that he has not, that the department should be permitted additional time to specifically brief an issue if you are not satisfied by my oral argument, which I suggest is sufficient, but you've raised lots of issues beyond the scope of the record.
Okay, thank you
And so
both.
I'm confused though about that statement that you just made. So I thought you were saying that it was okay to withhold this document from him because of this regulation.
Yes, it is. But if you determine that the only other right that he has to mail would be a constitutional right to freedom of association with regard to correspondence. And if your honors determine that withholding it is a violation of his right to receive this mail, under the Turner v. Safley analysis, it would suggest the department has a right to limit the number of pages that he can receive, even in a regular letter, if we were to choose to do so, based on the security concerns. And if you go through the whole analysis, again, I have not, because it was not raised below. But if you were to go through the whole analysis, I would believe even that would be permissible.
Okay. Thank you very much, both of you. This argument has been very helpful to us. Both of your arguments have been very helpful to us. So thank you. The case is submitted.